This is a story about power, about what happens when you have enough money to turn the legal system into a weapon, not to win a case, but to make sure the other person never gets to fight one. In 2025, Blake Lively's legal team subpoenaed Google and X, formerly known as Twitter, demanding personal data, bank accounts, credit card information, from more than a dozen journalists and small online creators. These weren't media empires. They were YouTubers with modest followings who had made videos about her lawsuit with director Justin Baldoni. 3 of them wrote directly to a federal judge asking for relief. One argued there was no evidence or sound legal basis for the subpoena to exist at all. Lively eventually withdrew those 3 subpoenas after public backlash, but kept going after others. Perez Hilton, Candace Owens, a YouTube astrologer who had done nothing but read public legal filings out loud. That's what legal intimidation looks like in Hollywood today, and it has a name. SLAP, Strategic Lawsuit Against Public Participation. The term was coined in the 1980s by 2 University of Denver professors, George Pring and Penelope Kanan, who studied hundreds of lawsuits filed against ordinary people, tenants, activists, journalists, not to win, but to drain them until they went quiet. The goal was never a verdict. It was silence. It was the 6-figure legal bill that forces someone to choose between their mortgage and their right to speak. Here's how it works. A powerful party files a lawsuit, defamation, breach of contract, tortious interference, against a critic. The claim may have 0 legal merit. That doesn't matter. The target now has to respond. They need a lawyer. Lawyers cost money. Discovery takes months, sometimes years. Every deposition, every motion, every filing adds up. And while the powerful party absorbs those costs like a rounding error, the target, a blogger, a small YouTuber, a whistleblower, goes broke defending a lawsuit they may ultimately win. The chilling effect is the point. When one creator gets sued, 10 others decide not to cover the story. California figured this out decades ago. In 1992, the state passed what's now considered the most powerful anti-SLAP statute in the country, California Code of Civil Procedure Section 425.16. Under that law, a defendant can file a special motion to strike within 60 days of being served. The court immediately freezes all discovery, stops the legal machinery cold, and puts the burden on the plaintiff to prove their case has minimum merit. If they can't do that, the case is dismissed, and the plaintiff pays the defendant's attorney's fees. Mandatory, not discretionary. The court must order it. That fee-shifting rule is the statute's sharpest tooth. Filing a meritless SLAP in California means risking a court order to cover the other side's legal bills. As of 2026, 40 states and the District of Columbia have some form of anti-SLAP legislation. California and Oregon offer the broadest protections. Idaho adopted one of the newest and strongest statutes in January 2026. But at the federal level, there's still nothing. No national anti-SLAP law. That gap matters enormously, because it's exactly where powerful plaintiffs go when they want fewer constraints. California built the shield. Hollywood learned to use it in both directions. The first thing to understand about the Hollywood SLAP is that celebrities sit on both sides of it. Sometimes they're getting sued into silence. Sometimes they're doing the silencing. And sometimes, in the messiest cases, they're doing both at once. Start with the shield working as intended. In September 2021, a studio owner named Chris Nelson filed a $3.8 million defamation lawsuit against singer Phoebe Bridgers. His claim was that she had maliciously destroyed his reputation with an Instagram post saying she had personally witnessed abuse, grooming, theft, violence that he had committed. Nelson called it a revenge plot. He wanted his money, and he wanted her to stop. What he got was an anti-SLAP motion. Bridgers' legal team filed immediately in California court. The discovery freeze kicked in. Nelson had to show his case had minimum merit. He couldn't. In November 2022, Los Angeles Superior Court Judge Curtis Kinn dismissed the lawsuit entirely. The California Court of Appeal upheld that dismissal in October 2024. The case cost Nelson far more than it cost Bridgers. In fees, in public attention, in the Streisand effect of making the original allegations far more widely known than they ever would have been otherwise. Bridgers' spokesperson called the lawsuit frivolous and without merit, filed with the sole intention of causing harm to their client's reputation and career. That's the anti-SLAP shield doing exactly what it was designed to do. A celebrity speaks out about alleged misconduct. Someone with resources tries to punish them legally. California steps in and says, "Not here." But the picture gets complicated when the celebrity is the one filing. To understand how A-listers weaponize the system rather than shelter behind it, look at what happened to Amber Heard. In 2018, Heard wrote an op-ed in the Washington Post. She didn't name Johnny Depp. She described herself as a public figure representing domestic abuse survivors and wrote about the culture of disbelief they face. Depp filed a $50 million defamation lawsuit against her in Virginia. Virginia had an anti-SLAPP statute. Heard's lawyers invoked it, arguing the op-ed addressed a serious matter of public concern. The judge allowed the defense. But Virginia's law was weaker than California's. Discovery wasn't frozen. The case went to trial. What followed was one of the most watched courtroom spectacles in modern history. 6 weeks of testimony, social media campaigns, a jury that ultimately awarded Depp $15 million, later reduced to $10.4 million by Virginia's statutory cap. Heard received $2 million on her countersuit. She later said the trial had set women back decades. The legal mechanics matter here. Depp had already lost a separate defamation case in the United Kingdom in 2020, where a judge found that calling him a wife-beater was substantially true. That verdict went unrecognized in Virginia. Different jurisdiction, different rules, different outcome. And the anti-SLAPP defense Heard tried to mount gave her some protection, but not enough. Because Virginia's law didn't make fee-shifting mandatory, didn't automatically freeze discovery, didn't give courts the same blunt power to kill the case early. The gap between a strong anti-SLAPP state and a weak one is the difference between a shield and a suggestion. What the Depp Heard case showed was a new template. Use the legal system not just to win money, but to control the narrative. The lawsuit becomes the story. Discovery becomes a stage, and the public watching on social media becomes the jury before the real jury ever sits down. If Depp Heard was the spectacle, the Kesha versus Dr. Luke case was the slow grind. In October 2014, Kesha publicly alleged that her producer and manager Lukasz Gottwald, known as Dr. Luke, had subjected her to years of sexual, physical, and emotional abuse. Gottwald denied everything. He filed defamation suits. Kesha countersued. What followed was nearly a decade of litigation that held her career hostage. In 2016, a New York court refused to release Kesha from her recording contract. Her music kept flowing through a label connected to her alleged abuser. The statute of limitations had expired on the underlying abuse claims. The defamation case dragged forward. This is what a SLAPP designed for maximum damage looks like. Not a single lawsuit tossed in 60 days, but a litigation strategy built to consume years of someone's professional life, to exhaust their resources and their will. Kesha couldn't speak freely about her own experiences without risking further legal action. The court system became the cage. Compare that to what Hollywood's most legally sophisticated celebrities have learned to do differently. They use California as home base. They structure their claims so anti-SLAPP protections work for them as defendants, and they file in weaker jurisdictions when they want to go after someone else. They retain firms that specialize in entertainment litigation, firms experienced enough to anticipate an anti-SLAPP motion before the lawsuit is even drafted. Jada Pinkett Smith showed the playbook in early 2026. When Bilal Salam filed a $3 million lawsuit against her, alleging she had threatened him after he made claims about Will Smith, her legal team immediately moved to have the case dismissed under California's anti-SLAPP statute. Their motion argued her public comments were protected speech on a matter of public interest. The mechanism was deployed within weeks of the filing, before discovery could begin, before costs could accumulate. That's the elite version of this. It's not just having good lawyers. It's having lawyers who know which tool to reach for, in which court, on what timeline. The Blake Lively situation reveals something even more layered. Lively filed her federal lawsuit against Baldoni in December 2024, alleging sexual harassment and a retaliatory smear campaign run by his crisis PR team. Baldoni filed a $400 million countersuit. In June 2025, a judge dismissed the countersuit. Then in July 2025, news broke that Lively's legal team had subpoenaed Perez Hilton, Candace Owens, Andy Signore of Popcorn Planet, and a YouTube astrologer, all as part of what her lawyers called a court-approved discovery process to prove Baldoni's team had coordinated with anti-Lively creators. The legal justification was real. The judge had permitted discovery. Subpoenas are standard tools. But the effect on smaller creators was indistinguishable from intimidation. They received legal documents demanding communications and personal financial data. They had to hire lawyers. 3 of them wrote directly to the judge, arguing there was no evidence linking them to Baldoni's team. Lively withdrew those 3 subpoenas, but kept going after Signore. His motion to quash was denied in December 2025 because he had filed it in the wrong jurisdiction. He had to comply. That's the question the Lively case forces into the open. Where's the line between legitimate discovery and using litigation to silence coverage you don't like? Her lawyers said this was evidence gathering, nothing more. Critics said the subpoenas reached people who were simply commentators covering a public legal dispute. The law gave both sides a defensible argument, and that's what makes it so difficult. When powerful people use legitimate tools in ways that look like suppression, the system sometimes has no clean answer. That's where the federal
Section
gap becomes
4 needs
critical.
clarification.
California's
Agreed.
anti-SLAPP
The language is
statute
too
can
vague.
only do
Let's
so
redraft
much when
it
the
now.
lawsuit lives in federal court in New York. A creator subpoenaed there can't easily invoke California protections. They fight in the jurisdiction where the case sits. And if that jurisdiction has weaker free speech safeguards, they're exposed. Free speech advocates have pushed for a federal anti-SLAPP law for decades. The Speak Free Act has been introduced in Congress multiple times. It has never passed. What's left is a patchwork. 40 state laws ranging from strong to moderate, and nothing at the federal level to stop a well-resourced plaintiff from choosing a friendlier forum. Entertainment lawyers know this. Powerful clients know this. Filing in federal court in New York rather than California state court isn't an accident. It's a choice. And that choice has consequences for everyone who isn't on the right side of the resource gap. The pattern extends beyond individual celebrity cases. Using litigation, or the credible threat of it, to shape coverage has accelerated alongside the rise of independent online media. Traditional newsrooms have lawyers on retainer, legal defense funds, editorial infrastructure. A YouTuber with 200,000 subscribers has none of that. The asymmetry is enormous, and powerful people understand it. Here's what all these cases share: Phoebe Bridgers, Kesha, Jada Pinkett Smith, Blake Lively. The law itself is neutral. The anti-SLAPP statute was written to protect the little guy, the activist, the journalist, the ordinary person who speaks out about a matter of public concern and gets sued into silence by someone richer. And it does that. It's protected thousands of people. Bridgers used it and won. Countless journalists and whistleblowers have survived lawsuits that would otherwise have destroyed them. But the same tool that protects the small creator can be deployed by the A-lister. The same statute that stops a powerful person from silencing a critic can be used by that powerful person to deflect accountability for their own conduct. The mechanism doesn't know who's righteous. It knows who filed the motion correctly and in the right jurisdiction. What separates the celebrities who navigate this system skillfully from those who get caught in it isn't virtue. It's resources. It's the quality of the legal team. It's the call made in the first 48 hours after a lawsuit is filed. Which law to invoke, which court, what timeline. Those decisions are made by people who charge hundreds of dollars an hour and have spent careers studying exactly these questions. And at the bottom of that system, making videos in their bedrooms, writing blogs, covering public court proceedings, are the people who receive the subpoenas, who get the letter from the law firm, who have to decide whether to fight back, fold, or go quiet. Most go quiet. The chilling effect isn't theoretical, it's documented. It's the intended outcome in many of these cases. A lawsuit doesn't have to succeed. It just has to be filed. Expensive enough, stressful enough, uncertain enough to make the next person think twice. That's the SLAPP shield in its most honest form. Not a tool for truth or justice, but a mechanism of attrition. In Hollywood, where image is currency and silence is often the most valuable commodity in any dispute, that mechanism has become as standard as the NDA and the cease and desist. California gave the public a sword. Hollywood learned to carry it in both directions. And until there's a federal law strong enough to stop forum shopping, until something protects a YouTube creator in a New York federal courthouse the same way California law protects them at home, the asymmetry stays. The powerful will keep filing. The rest of us will keep paying to respond. And most of the time, the story will never get told.